Mr. Speaker.
Dr. Lawrence Xu-Nan.
Thank you, Mr. Speaker. I rise on behalf of the Green Party to oppose this bill for a number of reasons. But I want to say, first and foremost, that yes, everyone should be free to travel around their communities and around our country without risking death or serious injury. And we can have that transport system that is free of death and that serious injury. And yes, it is true that no one should ever drive while seriously impaired, and it puts themselves and others at risk. However, there is a lack of evidence in this bill or the drug driving regime that will address the root causing dangerous or impaired driving or of drug harm. And I just want to unpack some of that as what we have observed in the committee stage. I think one of the first things is the Land Transport Drug Driving Amendment Bill has often been equated with drink driving. But the thing is, Mr. Speaker, we must understand that the way that we quantify and look at drink driving in terms of the interaction between ethanol and our body and our digestive system is vastly different from the myriad of drugs that has been discussed in this particular bill. Indeed, in Section 4, when we're looking at quantifying, or when we're looking at qualifying drugs, or a family of qualifying drugs under the definition, one of the things that we did try to explore during the committee stage was around the idea of what does it mean when something shares a substantially similar chemical structure, particularly in light of benzodiazepine or amphetamine. Because what we see, unlike ethanol, there are a lot of different compounds, particularly for medicinal uses. So for example, anxiolytics or potentially central nervous system stimulants for ADHD treatment is something that can have that particular chemical compound, particularly when we're looking at benzodiazepine and having similar structures as which benzodiazepine, for example, have in terms of having both a benzene as well as a diazepine ring structure in its chemical structure. The other concern that we have, for example, is the inconsistency when you're talking about pharmacological effect. So again, pharmacological effect is when we're looking at the interaction between a particular drug or particular substance with the human body, and particularly when we're looking at what is considered the first-pass effect through the liver. But when we are looking at some of these particular, some of these sections, let's say Section 12, Subclause 3, we're looking at the idea of proportional of the drug in the system. It's not simply about impairment, and it doesn't take into account that certain people process certain compounds faster than others. So naturally, what we are seeing, again, unlike ethanol, we are seeing possibly a discriminatory effect when we're looking at people being stopped for these sort of tests. And I think nothing in this bill that finds itself with the baseline of impairment, because a lot of these comes down to proportion of the available drug or the proportion of a qualifying drug in a person's blood. So it does base the question of, from the very definition of qualifying drugs, are we looking at a discriminatory element, and especially when you're looking at someone who is having certain mental health issues which will require certain drugs being administered, or indeed have certain neurodivergencies such as ADHD, not being a part of this. And we're seeing that even in the primary bill, under the schedule of what is considered a qualifying drug, it actually determines the actual amount that should be present in the system, but this bill, again, doesn't actually show those amounts, and we have no indication and no clarity from the minister of when that order in council will be made that promotes or that clarifies the actual amount within that in terms of families of qualifying drugs. So the example that I gave during the committee stage was bromazepam, which is anxiolytic, but it does share a benzodiazepine similar structure, but it's not currently in the schedule of a primary bill. So we do, the Primary Act, so we do need to have an amount that's specific to this. The other concern, and it also ties up in general, is very rarely, indeed, very rarely we do see a bill that fails the Borah test, and that's the Bill of Rights Act test here in Parliament. And this particular one does require the Attorney General to produce a Section 7 report. But I think what has been quite a disheartening factor about that is, even though there is a Section 7 report that has been done on this, there are a number of sections which I think would have been pertinent for the Attorney General, also for the government to consider under the Bill of Rights that has not been considered as a result. To give an example, when we are looking at, for example, I gave a couple of case laws on this particular issue. One of them is the Taylor and New Zealand Poultry Board case, which was from 1984, and it went all the way up to the Court of Appeal, which very much challenges the very essence of natural law theory, and particularly the presumption against self-incrimination. And indeed, this particular one touches on the Borah Principles 23, Subclause 4, 25D, and also 27.1, none of which were explored as part of the Section 7 report, despite the fact, again, we have a Section 7 report as opposed to a consistency report against the Bill of Rights Act. This is a serious concern because for many of us, we know that as under the Bill of Rights, we have natural rights under natural law, and one of which, the presumption against self-incrimination, very much doesn't allow us, or doesn't allow one as an absolute right, potentially, if you want to argue that, against self-incrimination. And by having a police officer or by having an officer pull you up and making you and forcing you to take a test, that very much touches on, some would say, one of the fundamental rights against self-incrimination. And I think one of the things that's been particularly evident in the Attorney General report as a result of this was actually that, yes, maybe one could argue that upon balance, and particularly if you're applying Section 5 of the Bill of Rights Act and the limitations, then maybe there is a reason for us to limit that particular right. However, we have also seen that there is no real that the oral fluid test cannot prove impairment. And that's one of the major issues, because it is not like alcohol, where the relationship between breath and blood levels is more strongly correlated with impairment. And yes, there may have been some that has been said in terms of the accuracy of this particular oral test, but to be honest, it doesn't actually offer the same level of reassurance as what we're currently seeing in terms of breath alcohol test. The other thing that I want to mention, as also part of the same vein in terms of potential challenges in terms of the Bill of Rights, is actually a very recent case where the ruling just came out a few days ago, which is happening Lawrence and Police, and this is in the High Court. It's a High Court ruling that talks about when a person, in this case Mr. Lawrence, was stopped by the police, he was allowed to consult a lawyer as your natural right to consult a lawyer. But one of the things that the officer failed to consider is that under Section 23, subsection 1B of the Bill of Rights Act, the right to consult a lawyer also requires a right to privacy, as in you are supposed to consult a lawyer in private. And because of the fact that the police officer just happened to be in the car with Mr. Lawrence at that precise time, it also meant that that particular test was considered inadmissible in court because of the fact that the Bill of Rights has been violated. So we're actually going to be seeing a lot more potential challenges when it comes to this. And this is in with regards to Section 27 of this particular bill, where it talks about an enforcement officer must forbid a person to drive a motor vehicle for a 12-hour period if the person fails or refuses to undergo an oral fluid screening test without delay. And one of the other things we haven't managed to get clarity on during the committee stage is what does without delay actually means. And I think what it does is it opens our enforcement officers up for a lot of legal challenges under the court of law. So to sum up, Mr. Speaker, that the Green Party will not be supporting this. Not only is from a pharmacological component that we have not gotten the reassurance that when you're looking at qualifying drugs or interaction of drugs or even drugs that is available for certain treatment of anxiety and also neurodiversity, that it does have the protection for those people. We're also seeing some severe challenges in terms of the Fundamental Bill of Rights Act, both through the Section 7 report and also through some of the case law that I've expressed. But there are other ways to deal with this. And I just want to leave with saying that unsafe speed is actually a factor in more fatal crashes than alcohol or drugs. Thank you.
Yes, well, I do think Lawrence brings up a very good point about Clause 4, because I had a look into it. Please tell me, Firebeard, if I'm popping in and out with my mic. But yes, it is concerning that some of these medications are actually necessary for someone to drive safely, like amphetamines for people with ADHD.
Yeah.
Lisdexamphetamine and dexamphetamine are both prescribed in New Zealand, and they would be picked up in this test. Stacey says, I'm a little bit roboty. Well, there's not much I can do about that because there's an internet connection issue.
It's not like you have a Starlink dish at your place to circumvent it.
No. But yeah, I mean, CBD oil is another prescribed medication that can be detected in roadside testing that may not impact driving. So again, some people can have impairment from drugs that may not be detected in roadside testing. Other people may not be impaired by prescription drugs that can be detected in roadside testing. So yeah, and these tests don't specify what drug you have taken. They do look across different families.
Yeah, I do know in Australia they do change to different colours depending on which drug it is. That's the fact. So that's what I've seen on the Australian cop shows, is that the colour of the solution in the test does show up with a different, which does have certain colours reflecting certain drug types of what is the chemical compound property. But I mean, what's the next bit we're going to do? Like, are we going to have, I don't know, equivalent to glucose sugar monitors that are going to measure the same thing of, we're going to have police going, prick your hand, please.
Yeah, just to acknowledge the chat about my microphone, there's not much I can do on my end because the internet's been crappy at my place pretty much all day. So, yeah, if I'm roboting, sorry.
And I also had issues getting into Restream earlier before we were to go live, so I've had those issues as well. So I know how you're feeling with when things go there. I think that might be, in my case, it's might be an issue with the DNS server with it, because that's somewhere some of the issues have lied.
Thanks for watching. Make sure you're subscribed to our